Okay. All right, trial docket. Let's start with that. Sorrel Solomon. And he's representing himself on this. And Mr. Ham,
Yes, sir.
y'all ready?
It is ready.
Okay.
We need to give with him as to last conversation with him was he was talking about potentially needing to subpoena some documents, and we need to see if he's actually ready to go,
Yeah.
Judge.
Well, Jermaine Reader.
Ready on.
All right.
Ready.
And Anthony McCullough.
Ready, Judge. If I had my preferences of trying Reader or McCullough, I'd rather try McCullough. I was still ready for Reader if you want to choose it, but
That's what we're
I
gonna
have a
do.
witness. I have a witness that I had to find that been gone for months, and I finally located.
Reader is first.
Huh?
Reader is going to
Okay,
be
fine.
first.
Yes, sir.
Okay, pause right there. Look at that energy. Judge Stevens is running this docket like an air traffic controller at a busy airport, and half the planes are on fire. We've got defendants here, defendants not here, lawyers who are double booked in other courts, and one guy who might be in the hospital. This is what we call the legal blender, folks. Everything goes in, and we pray justice comes out.
McCullough, you ready? And then
Ready?
as far as you know, it's 1,500 days. I mean,
Yes, sir.
how can the defense not be ready, right? I'm talking about the defense. I don't know where Tom is.
Oh,
He's not here, but it's Troy Steins is next.
Judge, from my understanding, you allowed that to be reset on Friday.
DeLester Brister.
He's present, Judge. Orange in custody. And I have a sort of qualified already.
I don't understand what you're saying.
I'm supposed to have surgery Thursday in Houston. So I need to go over there Wednesday. And therefore, I'd like to have an extension to or resetting.
Mr. Ham, are y'all ready on?
I am, Judge.
How long would that take? You think? To try?
That was a short one, Judge.
Okay.
I may be able to work within the time frame that he had.
Okay. Todd Robertson
Ready, Your Honor.
and Tommy Williams.
Same thing, Your Honor.
Frederick Wiltz.
All three of those are same thing, Your Honor. Ready?
Okay. Can you try him at the same time?
I can try.
Kenlon Falk.
I'm ready on that one, Judge.
And Judge, Mr. Falk called this morning and said that he was in the emergency room. I don't know if you want to call him. I told him that he needed.
Isn't Langston Adams the attorney?
Yes, sir.
Yes, I did tell Mr. Falk that he needed to submit some paperwork for the hospital to get with his bondsman, but like, again, I don't know if I want to
Okay.
accept tentative finding.
Ronald Pulse. Mr. Coleman on Ronald Pulse, y'all ready?
Your Honor, I filed a motion for continuance on this. I have a case left over murder trial that I'll be starting this afternoon. It's essentially a priority setting.
I thought you were working over here. No, really? You're working both courts?
Judge, that's just a refresher memory. We talked about it last week.
Yeah, like I can remember.
No, Judge, this is the
The
last.
5,000 cases.
This is the last trial that Mr. Coleman has left over for the 252nd. There were 4 co-defendants.
That's right.
And so he's trying that this.
The last of the 4,
These are
Judge.
just cases that we need a new announcement on now that Mr. Coleman's on the case.
Who's the prosecutor on that one? Who's the prosecutor over there on that case?
On the murder case?
You're going to be.
Yes, sir.
right? Okay.
Yes.
Orlean Neely
Same announcement.
Ready, Your Honor, but you, Mr. Williams here.
and Richards and Murchison.
I filed continuances in both of those.
All right. So Jermaine Reader is first. McCullough is second. The Brister's third. Robertson's fourth. Williams is 5, we'll go through 6. That's that order. Thank you. Here's the 5.
Please bring Mr. Solomon out. Something on the records for them.
No, yeah, just. We're not gonna deal with him until we have to deal with him.
Okay.
David Booth. Oh, I need. Yeah, let's see what he's gonna do. Thanks. David Booth. MTRP disposed of. Okay, MTR disposed of. Then this is the only other pending case on Booth, I guess, right?
I'm good.
I'm looking at David Booth.
Oh, you want to come on?
No. Yeah, we got an announcement. Yeah. Yeah, it's a aggravated assault with a deadly weapon. It's an announcement today.
Oh, okay, that's what I thought. I thought you put me on a trial back for the day. I didn't say,
One.
yeah. Hey, I had to work some miracles if you put me number 1 today on that one. If I'm not mistaken.
What's?
Yeah, I thought you said trial back.
No, David, no, we already did that already.
let me get it.
We're into the
Time, this is-
regular docket. I'm just trying to get this done.
You're missing. You know,
All right, I got him. I'm just.
This is Mr. Booth. If I recall, you had already did the MTRP. I think you had an MTRP on him.
Yeah, it was disposed of. What happened on, what was the disposition?
I thought you gave him 2 years, but I could be wrong. I'm going off the top of my memory, but I do remember you doing the MTRP.
Yeah, I'm looking at, it says MTRP is disposed of.
And
So this is what's left.
Yes, sir. So I had that one with Mr. Laird. So I just need to confirm with Mr. Laird.
Why are you pointing at me and calling me name down?
I know, right?
What are we doing?
My client recalls that with the MTRP that I was supposed to get rid of this case too, but what you said, yeah, because judge had already sentenced him on MTRP.
Okay. And I was supposed to,
Years.
He received 4 years. That's right, 4 years. Yeah.
and I agreed to get rid of an aggravated assault with a deadly weapon. I gotta look at that.
Take a look. I'm just.
Is it on paperwork? Did you look?
That's what he was telling me.
Let me look at it. Give me a moment. A couple of moments, 15 minutes. What did you say?
Was the MTRP based on this event?
I think so. If I'm not mistaken, yes, sir. Yes, sir.
You need that witness to do that?
But I do remember the MTRP hearing, Judge. And I did remember you made a decision. I just couldn't remember the exact time.
What is house at the top?
I am right about that. And then while we waiting, I'm gonna sign up, Sandy, that's a plea. I'm gonna get that done today.
Okay.
That's the next one you got, but I need to sign them up.
Which docket is it on?
That's same.
This
document.
announcement?
Announcement, yeah, that's gonna be a plea. I'm gonna sign that one up as we speak.
Oh,
As we speak. But on this one, Mr. Booth, that was 4 years you did that.
what was he on probation for? Do you remember?
For credit card fraud.
Credit card fraud.
Just the autopsy stuff you need.
So it had to be,
Fraud, Judge.
That's 4 years, so it was above a state jail felony, so he must have prior.
This is the one.
Most of those are state jail felony,
Yeah, this one.
unless there's prior conviction.
Okay.
What did y'all decide, Mike?
Judge, I'm showing I've already dismissed a robbery on him. I don't know what he's talking about this. I gotta look.
No,
at
this is aggravated.
I know. So I'm looking. Look.
It says, striking the victim about the head and body with a bike chain. Huh. And let's see, struck her in the right hand with a bicycle chain and stabbed her on the left side of her neck with a mail opener type knife. Was that the basis of the revocation? The allegation in the revocation?
Yes, sir, to my knowledge.
Judge, on the judgment, it says he pleaded true to count 5, which was, count 5 was a failure to report to the probation.
Y'all gotta be accurate with me. Because, I mean, we'll check it, and
I'm looking, Judge. I had.
That wasn't the
my
bad-
notes.
that wasn't the ground that we revoked him for.
The police
So,
papers.
yeah, we didn't revoke him for this allegation, this indictment. It's for administrative matter. Take your hat off, please. This is a court of honor. Thank you.
Whoa, did you catch that? A bike chain and a mail opener knife? That's not a fight, that's a horror movie. But here's the legal twist. Judge Stevens is a genius for asking if this specific violence was the basis of the revocation. In probation law, you can't just throw the kitchen sink at a defendant. The violation has to match the paperwork. The judge is literally reading the fine print to make sure the state is playing by the rules. That's a masterclass in judicial scrutiny right there.
While we're waiting, what about Cyrus Sandy?
I'm signing it up right now. That's a
Okay,
plea for certain.
DP, okay.
That's gonna be a plea.
Okay. What about Dan Shelton?
He is incompetent.
That
I'm sorry. Go ahead.
was reset.
Oh, they reset it? Yeah, and I got a copy from this for you, Judge. Hold on a second, I'm gonna get it to you. Give me one of them. On Dan Shelton.
Yeah, what about Shelton? Oh, he's got more than one, huh? He's
Right,
got 2 cases.
but here you go.
So it's the same thing.
Right, but here's for you. I think I got this for you. 1, 2.
You know what?
Here you go.
Did you pull those already?
Yes, sir.
Yeah, she pulled them. I don't have the files.
Right. Okay, but that was
What
that was is from Judge Holmes's court, the finding of incompetency. That was in 2025 in September from Dr. Sapon. That's on Shelton, Dan Shelton.
Yeah, but he didn't commit the crime until March 17th of 26. That's the key thing. He's finding in September of last year he was incompetent. That doesn't mean he didn't gain competency.
Yeah, but
And when he committed the crime, I don't know. But I mean, it needs to be determined. The event
right.
was a half a year later. So, I mean, they gain competency, you know that. They can do it the next day or the next month. But, hey, did you want it?
I just want to get it to you for the file.
Is that, this is for me?
Yeah,
All right.
That's for you.
Anything we filled out for a plea agreement, I don't see anything we filled out for a plea agreement. On the MKRP. Did you do it? I'm not seeing any agreed plea on it. So glad to that.
Can you pull the MTRP
Judge,
data?
I'll have to go look and see if we still have the file. It's
Mike, can we come back to him?
over
Yeah.
and done with.
Yes, yeah, we need to come back to him because I don't see any notes anywhere on anything that says we agree to that. We're nothing on the record. May have to get the plea out, whoever did the plea.
Okay, no problem. Just let me sign Mr. Sandy then. That's who you, that is a plea for certain. I'm gonna sign him up now.
Okay, just have a seat in the box there, sir. So,
And I'm
We can
signing up
figure this
Sandy
out.
as we speak. Let
uh,
me go get him.
David. And then,
I'm signing up Sandy now.
what'd you say on Turner? David Turner? You got that one. That's an
On-
announcement. It's assault family violence.
On him, can I have just one reset on him only? And I'm going to sign up Mr. Sandy now.
Hold on.
Yeah, you want
You right.
do what?
Yeah, he's filing out. He's filing motions on your behalf. In this file. He's got a motion.
Representation.
Well, no, he's got a motion for Class A misdemeanor, state jail felon from the state jail felony. The only problem is this is third degree felony. It's going to be hard. It's going to be hard to reduce the third degree felony under 1244A. That doesn't work. That doesn't stop them. God bless.
All right, guys,
Pick that up for me.
I'm signing up Sandy now.
Thank you. All right. Don Sean Craig.
Judge, that's going to be a dismissal as soon as the victim gets the non-prosecution affidavit signed. So I guess for today, just do a reset until they can get that done.
My staff left. The lawyers are gone. We're closed.
Do we even need them?
We're closed. Okay. So you're saying Sean Craig is to be dismissed?
Yes, sir. It is. I don't know if it's going to be done today yet because I think he's waiting.
Who is the Laird?
Mr. Laird.
Okay, he seems to be busy.
He's tied up, right?
What about Glenn Cunningham?
That one actually has already been reset. Hired Scott Rennick.
Glenn Cunningham, 2 cases.
Yes.
Gary McWilliams.
The plea were ready to go.
And the other one is a Christopher Salinas.
That's a plea ready to go on it as well.
All right. We need Gary McWilliams. He's in custody?
Yes.
Thank you.
Yes. They're both, let's see, McWilliams is no, sorry. Salinas is 205 plus restitution. The other one's. So I say that all. What is it? Say it all. Thanks.
Come on up. You're Gary McWilliams? You need to go in front of this lady. Thank you.
Raise your right hand for me, sir. Swear or affirm to tell the truth, everything that the truth, so help you God. Each of your right hand. I need it much darker than that, stepping in. It's okay. Oh, well, right here.
If he doesn't take that today, I'm gonna follow.
So place it flat right here, don't.
It's gonna be a Mitchell song.
Okay, that.
That's fine. You didn't want to do our non-gross sale. That's today. It would reset until these.
I get it, yeah. I'm gonna get it first.
23 CR 138 call. The state of Texas versus Gary Michael McWilliams. That's you?
Yes, sir.
Present with your attorney, Mr. Dusler, and the state's attorney does. The defendant waive a formal reading of the indictment and arraignment here. Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about May 21st, 2023 in Jefferson County, Texas, you committed the state jail felony of theft of material, and it looks like it's copper. Do you understand what you're charged with here?
Yes, sir, I do.
Absolutely. If convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached in your case where you would be pleading guilty, sentenced to 1 year in the state jail. Is that your understanding of the plan?
Yes, sir, it is.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
They got caught at the scene, so the people didn't lose their stuff, right? Everybody?
They caught him in the act.
Okay. If I follow this agreement, you have no right of appeal and you will be given credit for all time you've served in accordance with this case.
Yes, sir.
How do you plead to this? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that? Understand it? Discuss it with your attorney? Are the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered.
No objection.
Without objection admitted. Among other things, this states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes, sir.
States Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived
Yeah,
here.
sure.
I will follow this agreement. I'm going to find that you are mentally competent to enter your guilty plea. It is freely and voluntarily made. There's sufficient evidence supporting your guilty plea from States Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this state jail felony of theft of material, namely copper. And following this agreement, you were hereby sentenced to confinement with state jail for 1 year. Do you understand what has happened today, sir?
Yes, sir.
Okay. Is there anything else you have pending?
No, sir.
Thank you.
I have Christopher Salinas.
Going back.
Oh, boy. Ran out of blue ink. I'm completely out of blue ink. What's this? Nope, I got one.
Salinas,
Go over in front of that lady. Thank you.
raise your right hand for me. You swear or affirm to the truth and nothing but the truth of your okay, either on the right thumbprint, your whole thumbprint. Or you
Both the whole
flat on the
thumbprint.
box right here. Okay,
Okay.
get up one more time. Place it flat right there. Okay, and you go say hi, Judge.
Okay. We now call 23 CR 1792, the state of Texas versus Christopher Salinas. Present. Okay, present. Mr. Dusler, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary? Yes, sir. In summary, sir, this indictment alleges that on or about July 10th, 2023 in Jefferson County, Texas, you committed the state jail felony of criminal mischief. Let's see. It says intentionally and knowingly damaging or destroying tangible property, namely a chain fence, by cutting the fence with wire cutters. And that was the loss of $2,500 or more, but less than $30,000. That constitutes a state jail felony. Do you understand that you're charged with here?
Yes, sir.
If convicted, you face no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can also be assessed. Do you understand the punishment range?
Yes.
An agreement has been reached where you would be pleading guilty, sentenced to 2 years in the state jail. Then that would be suspended. You would be placed on regular probation
Judge, there's also restitution.
for up to 5 years. Yeah, I hadn't even got to that part, but I don't see how much rest. And it says restitution, but there's nothing filled in.
We showed $9,549.
Hold on, let me try to work this device here. But is the eraser. All right, once again, it's how much?
$9,549.
Restitution equals $9,549, and that would go to the victim in this case,
That's
as
correct.
alleged in the indictment. Is that your understanding of the plan here?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty? Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
I show you what's marked as State's Exhibit 1. Did you sign it? Understand it? Discuss it with your attorney. The contents all true and correct? State's Exhibit 1 entered into evidence. Without objection, it's submitted. This states that you are mentally competent to enter your guilty plea freely and voluntarily. And if you know what you've been charged with, Ms. McGrath, you've read it. You are guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1. This is part of the record for purposes. Pre-sentence report is waived. I'm going to follow this agreement. One thing I want to ask is you're going to be ordered to pay back restitution, the loss, in the amount of $9,549. How are you going to do that?
I gotta find a job.
When was the last time you had a job?
Back
Years?
No, it was,
You're homeless though, aren't you?
I was living with my girlfriend. I had a job. I was a home care provider for a friend's daughter. I'm gonna see if I could get that job again.
Okay. Are you a licensed home
No, so
You just,
it was a friend's daughter. She was sick. I was just washing the clothes or maintaining the house.
what do you have a skill for?
I'm a great handyman. I was working out in the oil fields. I just need
Well, what were you making then? An hour? A lot, probably.
22, 27.
I was gonna say 30 at least, but
Yes,
man,
sir.
okay. Well, that's 50 grand.
Yeah, I could get that job again. It's because ever since I lost my vehicle, I've just been doing bad. I've been trying to stay up, but it's just everything just kept falling down on me, and I'm still happy. Like that's one thing that my life hasn't
Well, let me
done.
just give you a word of advice is you don't, your story of life isn't really much different than ours. I mean, we got good days and bad
Yes,
days.
sir. Yes, sir.
And it's like 2 steps forward and 1 step back in everybody's life.
Yeah, mine was like 10 steps back and 1 step forward.
Well, why was that?
Ever since my childhood, I've had a rough life.
Welcome to planet Earth.
Yeah.
Everybody's got a story.
Yes, sir.
I'm not, I wish I was. Yeah, I wasn't born in a millionaire's home, and
Yes, sir.
we're that. But anyway, the point is that your story is not much different than probably most people. The point is, this is fixable, but you got to fix it.
Yes, sir.
How many criminal convictions do you have?
On the top of my head,
See, fix that.
yes, sir. It's weird. It's weird. It's like
No,
it happened when I was 17. It happened when I was 27.
well, I know, but the 17,
It's like a 10-year.
you've gone through 12 years of schooling. Come on.
Yes, sir.
You know, we make choices.
Yes, sir.
We make good choices and bad choices. When we make a good choice, we reward it. Bad choices, we get punished. And we really, you're from what I take it here, from looking at this, you're smart enough.
Welcome to planet Earth. That's the line of the day right there. Look, I love this moment because Judge Stevens isn't just throwing the book at this guy, he's giving him a reality check wrapped in tough love. He's saying, your story is sad, but it's not an excuse. Here's a question for you guys in the comments. Did you find this speech compassionate, or was the judge being too hard on a guy who is clearly struggling? Let me know below, because this is the courtroom drama we live for.
God, you're wise enough to know right from wrong and what is the best choice and what isn't. Fix this.
Yes.
Move on with your life, get the trade, and if you get into the oil business
I plan on getting
out there, you know, you're going to make a lot of money, and you'll be able to then do good things
Yes, sir.
with it
Yes.
rather than bad things.
Okay.
I keep finding you, I don't seem to know. Anything else to add by anybody? So again, there is sufficient evidence supporting this guilty plea to find you guilty beyond a reasonable doubt, and I find you guilty beyond a reasonable doubt of this state jail felony. I'm following this agreement. You were hereby sentenced to confinement in the state jail for 2 years. That is suspended. You are placed on regular probation for 5 years. You do well, fix this, pay this back. It will be shortened in 1/3,
Okay.
which is a year and 2/3,
Okay.
18 months. Essentially 18 months, 18 to 20 months. You must pay restitution in the amount of $9,549 to the victim complainant, as that name is here in the indictment. If you fail, your probation could be revoked and you can be sentenced up to 2 years. How much time does he have?
I could have at least 5 months back time.
Yeah, you would know better than anybody.
Yes, sir.
Because I'm sure you don't forget that.
Yeah.
Nobody ever does in this room who's going through it. But you don't want 24 months.
Yeah, I don't.
Fix it, move on, make a life that's independent, and that is of doing good things.
Yes, sir.
Anything else? That is all. Good luck. You're going to see the probation office. He's going to go over all those terms, you sign it, and you can move on.
Going back to that, John Craig, when she wasn't here, I think we want to go ahead and reset that a couple of weeks till we get the non-prosecution indictment in the district. So
Okay. Sean Tremaine?
yes,
And did we need that person out?
no, sir. No, sir.
Okay, how much time do you,
Just a couple of weeks till I can,
is 2 weeks good?
whatever you want, 2 or 3. As soon as the victim signs a non-prosecution agreement, they'll issue an order of dismissal. We'll even need to be back.
Okay, well, when is that going to be done?
I hope so. So I'm saying 2 or 3 weeks should take care of it. Whatever you think's a good reset.
Well, I mean, is it ready to go and be signed?
Yeah,
by
we're
the
just,
state?
just waiting. We're just waiting.
If they show up at my office, what the process is they contact me. I go talk to them for briefly just to make sure that's really what they want to do and
Yeah,
it's somebody
yeah.
personal. And
But
we
it's
do it that
generally
day.
it's
Can
what
we do
they-
it that day. Yeah.
It gets done generally.
that day, right.
Very few times is there, oh, we had this all wrong. We're going to go about our business in a different way. Yeah, generally, y'all get it done
Yes.
when they understand and see if face to face. And is 2 weeks going to be good, do you
Yes,
think, on
I
that?
think,
Okay,
yeah.
all right. We'll review it in 2 weeks.
Okay, thank you.
Thanks, Don. What else, Don?
That's it. That's all I've got.
Okay, I have Nathaniel Clark.
That's please.
That's, it looks like
Yeah.
Brendan Manning, Mr. Manning. Where's,
He's signing in the back.
he's at the back.
Mine is ready.
William I'm
Mine
sorry.
is ready for you now.
Langston is which one?
That's
Cyrus,
Cyrus. He's ready right now.
come on up. Cyrus Sandy, Cyrus Sandy.
Yes, sir. He's done. And then on who we got him figured out too.
Oh, do you? Okay.
Mhm. But Sandy is sent to you.
Sandy.
Let me get Mr. Sam. Hey, oh my God, Mr. Falk that's on the trial docket at the
Yeah.
hospital. Are you gonna reset him or?
Well, I don't know. I gave,
Is he gonna be reset?
Things in case we do not get any paperwork from the hospital. You know, he says he's in a hospital, but I don't have any paperwork to back that up. So
Yeah.
we do need to make some findings
What kind of fine?
tentatively, just in case.
Do we just need to call his name and call him in the hallway that way in case he doesn't bring anything and we file something?
Doesn't, if he doesn't.
I'm not following this really well.
Because if he's in the hospital, we know he's not coming. If we call his name, there's not gonna be nobody to call.
Well,
Okay, but
But what if
But
he doesn't produce any paperwork from the hospital? I have nothing to back that up other than him
Yeah, but
calling me on the phone.
there's nothing we can, what can I do right now about that? I can't produce
The state's
paperwork. You don't
asking-
have paperwork, do you?
No, sir.
We're asking that we call his name in the courtroom and outside. If he does produce the paperwork, then that will be okay. But if he doesn't and we file something,
I know, so he's not gonna be out there. So so there's no answer. Then what do we do next?
we're waiting, we're giving him time to produce something as Lacey requested. And if he doesn't,
Well, how are we doing that? If he's not here, if I order him to do it, I'm not communicating directly with him. How do I do that?
Judge, in the past, you've made tentative findings on a bond forfeiture. If they've submitted if they submit paperwork, then we don't.
What you're saying is we're gonna treat this as though it could be a bond forfeiture.
And if he, and I'll.
Because he's not here, he's saying he's in the hospital, but we don't have verification of that in our hands.
Correct.
I
So,
understand.
yeah, so
That's what we'll do.
if he submits paperwork, obviously we won't do the warrant. But if he doesn't, if he's not able to produce paperwork, then we'll
Okay,
follow through with the bond.
let's take this man, then we'll go to that other case.
Sandy.
Okay.
And we'll make findings.
Yes, ma'am.
Okay. Ink up your right thumbprint. I need the whole thing. Not just that. Right there. Okay. One more time.
All right.
Okay.
Good morning, Judge.
Thumbprint up all day.
How are you?
I'll let you know.
About 5 o'clock?
Sunset.
Okay. Fair enough.
So,
26 CR 410 is called the State of Texas versus Cyrus Sandy. You're Mr. Sandy.
yes, ma'am. I mean, yes, sir.
Generally, they don't mistake me for a girl. That would be, but you had it narrowed between one or the other, and it was a 50-50 shot that you had. You're here with Langston Adams, who is your attorney.
Yes, sir.
And does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, sir.
I see we got two paragraphs here with an enhancement. Are we passing on the enhancement part?
We are, Judge.
Okay. In summary, this indictment in paragraph 1 alleges that on or about March 2nd, 2025 in Jefferson County, Texas, committed the 3rd-degree felony of fraudulent use or possession of identifying informations information or items, which is in a number of more than 5 but less than 10 pieces of identifying information. And these are credit card numbers and debit card numbers. And that was without the consent of the people whose names were there on those items and without their permission. So this is a 3rd degree felony, which means you're looking at no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
Agreement's been reached in your case where you would be pleading guilty, sentenced to 7 years in prison. Then another case, 25 CR 1443, would be dismissed. Is that your understanding of the agreement?
Yes, sir.
I'm gonna write a 7 in here too, the numerical 7, just so that there's not a. No problem with it. Okay, 7 years confinement. And the other case will be dismissed. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
Is there any restitution?
I don't believe so, Judge, but let me check on the process. No, we have not received any claims, Your Honor.
How do you plead to this charge? Guilty or not guilty?
Yes.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that? Understand it?
Yes, sir.
Discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence
No objection.
and without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived here.
Yes, sir.
I will follow the agreement and find that you are indeed mentally competent to enter your guilty plea. It is freely and voluntarily made. There is sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this 3rd degree felony, fraudulent use or possession of identifying information, items, we got to correct the indictment here, the caption. It's got items less than 5 but more than 10, which arithmetically can't happen. Correct it. It's in the caption, so it's not part of the body, but it's still wrong. Yes, it's good. In the body, it's correct. All right, that's been corrected. There is sufficient evidence supporting this to find you guilty beyond a reasonable doubt of this third degree felony. I now find you guilty beyond a reasonable doubt of this crime. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 7 years. And you will, of course, be given credit for all time you have served in accordance with this case. Do you understand what has happened today, sir?
Yes, sir.
All right, that is all.
That's it. Thank you. Appreciate it. All right, good luck, y'all. All right, take it easy. Mr. Falls. Ms. Moore.
Here you got it off on.
Yeah, I've got David Booth and David Turner still left.
I thought he was gonna reset Turner on Booth.
Yeah.
He's adamant saying that he didn't do that. But I want to bring him out so you can hear. Let me get Mr.
Wait. One thing at a time.
You want to?
Is it Turner that,
That's the one I was gonna ask. Just one reset on Turner.
where is he? Back there?
He's in the back.
Okay, state. Okay, I'm gonna grant that 1 week resetting on Turner, and the other is.
You want Falk? Well, Falk, I give the Booth is here. I can get Booth if you want.
Which one is the one that's theoretically in,
On the trial docket, Judge, let me pull that file.
That's Mr. Falk.
okay, let me know some findings on him real quickly. Where's my file? My, there it is.
Actually,
Means he's at the hospital.
Okay, we're talking about Kinlan Falk, correct? In 25 CR 1228, the defendant is indicted with the second degree felony of aggravated assault with a deadly weapon. But the prior convictions, there are 3 prior felony convictions. They look like they are in sequence. He is an habitual felon.
yes.
So he's looking at 25 to no less than 25, nor more than life imprisonment if found guilty here. And the defendant is not here
Right.
and purportedly is,
But we did understand that he was on Zoom in the hospital in County Court number 2. So he appeared, but
well, all we can really say is he appeared to be in the hospital.
That's what I told defense counsel. He's at the hospital. It doesn't mean that he is the one who's getting treatment.
Yeah, and we're going to be.
well, let's say this.
Look,
He could be
we're gonna trust, but we're gonna darn well verify. So that's what we're going to do is I'm gonna make some tentative findings.
That's fine.
Because I trust you, I'm not trusting this defendant. But I will find that he purportedly is unable to be here today because he is in the hospital. And which hospital did he purportedly be? Was he purportedly
I'm not sure. No, I didn't see it. I'm not
a
sure.
hospital
Judge.
on the planet Earth somewhere?
Right.
So the court is going to do this. I'm going to make tentative findings that he's unable to be here. So we're going to reset this case. He is purportedly unable to be here. He must have, as soon as possible, written confirmation that he is in the hospital being treated inpatient at this time, this morning, for this court to verify his inability to be here. Failure to do so, of course, can result in a revocation of his bond, among other
Yes, sir.
sanctions. But we will note that he is looking at 25 to life and as an habitual felon, according to this indictment, and this court's experience in this job has shown that people facing habitual felon status can act desperately to avoid being held accountable to trial in such a case. So he must have, the court shall order the defendant to have written confirmation of his hospital status to this.
This is where the honeymoon ends. Judge Stevens just said, trust but verify, and then dropped the hammer. If this defendant doesn't produce proof he's in the hospital within 24 hours, a warrant is going to pop and his bond is gone. This is what happens when you're facing habitual felon status. The system gives you 0 inches of slack because it knows defendants in this position, facing 25 years to life, might be tempted to disappear. That judge is running his courtroom like a tight ship, and I am here for it.
Court within 24 hours. Failure to do so, the court will issue a warrant for his arrest and revoke his bond. We'll call it in the morning and see what the status is. Okay, thank you.
Thank you, Judge.
All right, yes, sir. What else?
I thought you wanted to hear from Booth. Let me get him to come on out real quick.
Okay, and what is this for?
He was offered 7. You revoked him on the MTRP at 4, and he's telling me that he's absolutely innocent. So,
Okay, well, I'm gonna talk him out of that.
no, I just want you to hear it. No, no.
Where's Booth's spot on?
Here you go, Judge. You had given it to me.
All right, bring him out. We can do with that. Let's see, Booth. David Booth.
I have Mr. Booth.
All right, we're back on this 26 CR 605. So go ahead. It was
Right, you know,
set for an announcement. So what's our announcement?
the announcement on Mr. Booth is he's saying that he is not guilty. of
Okay,
anything all
so
over.
we go to trial.
Yes, sir.
That's what we're going to do. And Mr. Booth, this one's a second-degree felony, aggravated assault with a deadly weapon. So you're looking at no less than 2, no more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand the punishment range you're looking at? Let me look at one thing.
Texas ones, ladies. You please return the call. Which we're watching, we'll be there. We'll be doing this afternoon. Go no, we just have to eat it tomorrow morning, 30 miles. So that one lady is looking served today. That one says she didn't see anything to happen.
Okay, who's the prosecution on that? That one? Yeah, it looks like Mr. Laird. Okay.
Hey, Mom.
Yeah.
Get the NTRP pulled. It's in scanning. I don't have the NTRP that Judge wrote on, but I do have where we wrote that Judge found number 5 to be true and revoked him to 4 years. So it was not an agreement.
There's no agreement on that.
There was no agreement.
Okay. No. I didn't say anything.
All right. Yeah, look at this. And the concern one has is the victim appearing, and it's obvious the defendant doesn't think she's going to show up. I mean, we've done this enough. This is a homeless group that we're dealing with, and he's rolling the dice on she won't show up. So we're just gonna set it for trial and see what happens. That's all we can do. But you can't have any contact with the victim nor anyone on your behalf. If that happened and we caught that, that would be a new crime. And then you would be subject to more prosecution. So let the system play out without interfering. That is all. I have a Sean Craig dismissal. Do I sign that?
That was on
To
the,
be dismissed, yeah. 26 CR 371. Dismiss. Comments, okay. I hadn't seen Reagan Minaldi. Really? I hadn't seen her.
working hard.
Is she?
Or hardly working, I'm not sure.
She always works hard. All of our public defenders.
Always with kids when she's.
I'll stand up for our public defenders.
And she signed up.
Who you have? I don't have.
That's Nathaniel Clark.
Mr. Manning is ready on with Nathaniel Clark.
Yeah. Yeah. Who's
on the product?
Oh, he's on the trial docket?
Yeah.
Oh, okay. Okay. Yep. What are you sitting around for? We don't try this thing until 1.
Oh, you
You're gonna bill me?
That would be the way to get paid out. But,
That's not the right way to do it.
all right.
All right.
I was just waiting.
Who's ready? Come on up.
Mr. Manning is on the Nathaniel Clark.
All right. Daniel Clark?
We'll sign that. It's just the certificate of discovery. I'll give that to you. Whenever you get yeah, I'd get my minors. Step one. That's just the chat.
We laugh at whatever you wear.
Thank you, Judge.
And Nathaniel Clark,
Oh, here, please.
right there first, and then come back.
Clark, please raise your right hand.
Did you visit with Miss Turner?
Do you swear or affirm to tell the truth, whole truth, and nothing but the truth, so help you God? Okay, need to get your thumbprint. Right thumbprint. You're supposed to flat on that box over there. You can have one more time. One more time. Right outside the box.
Well, all those are good. Not being.
Okay, perfect. Thank you. Step in front, Judge.
Half marathons, the Vatican, my favorite. Plus the music and food was off the chain.
So it's been awesome.
When I went there, I went to Avery Island, which is a visit.
Yeah, it's nice.
It's called the Zydeco Cajun Festival. I remember right. Okay.
Thank you.
Okay. Explain to me what we're doing here. He's an habitual felon, right?
Correct, Judge.
Okay, so he's looking at 25 to life, but y'all are just abandoning his prior convictions and just going on the 3rd-degree felony
That's correct.
of DWI.
Yes.
How do we sell that to Mothers Against Drug Driving in this county?
Well, the reason why I made the decision is because of the age of his priors and the facts and circumstances of this scenario. In addition to his particular age, I felt like justice would be best served with this agreement, Judge. And if they have any points, they can visit with me about it. I'll go into detail.
I don't like things. Okay. Too much crying and weeping that goes on in this room because of intoxication. You get it wears over 20 years. And here, I mean, it's just not your first. This is your third DWI. Plus, you got an illegal possession of drugs conviction in 97, and then a felony conviction, what's it, aggravated battery in 99. But it's a 2012 first conviction out of Wichita Parish, the DWI. And then after that, in 2015, another conviction, and then this one. I mean, the thing is these are 4 prior convictions that you've had, and they're all serious. 2 of them are felonies, but now this one constitutes a third felony conviction. Man, no, we're gonna go to trial. I'm not gonna handle it this way. We'll let the jurors decide what's appropriate under his circumstances. Okay, thank you. Yes, we'll set it for trial. All right, we got Jamal Mishaw. And we'll Jamal Mishaw. It's that's Brent. Where's Brent?
So he's next door, Judge. All his clients are on that side.
We just ran out of room. We have a group of inmates on the bridge, so.
Okay, because I've got a cluster of his. 1, 2, 3, 4, 5, 6. Okay. I was looking for Brent because I couldn't. What about William Gardner?
Judge Mike is considering a counter offer on him. If we could have a week,
What do you want on Gardner to do?
just a week resetting judge. He needs to
All right.
contact the complainant to
All right,
see.
William Gardner, reset 1. Thank you. But one more here. I've got Donald Miller.
Judge, I believe my office filed for a bond reduction for him, but I don't see that notated on the docket. I know the state has to have proper notice of it, but if we could reset him a week too.
You sure? Oh, with John. Oh, John was not my, it's on side. Yes, sir. Didn't touch that. Sorry. Oh, confused. He'll ask how you live there. He has time the video on something. Yeah, we should, but that's what you want to read it, that's all it is. You're right. That way, so I'm gonna probably bring it from that, but then Ashley Bradley. Yes.
Okay, on Donald Guillory, that's Miss Moore? Can you,
Yes, sir.
on Donald Guillory? What was, it looks like, did the victim almost die in this?
No, sir, he, injured his leg.
Said surgery was required on the victim due to severe leg injury along with head injury and road rash. That didn't sound good. And it says, knowingly and recklessly caused serious bodily injury to the victim. That's gotta be. So it wasn't serious bodily injury?
The indictment is correct, Judge. I know he had surgery for some injuries to his leg.
Okay. Because they're asking for a reduction in bond here, and we're gonna have a hearing on that when we can, but this, to me, it's the seriousness of the injury is gonna have a lot to do with everything.
And I can speak to him more. I spoke to him, but we didn't speak.
But I mean, it's
So he turned, he said, "Well, we're gonna find a new friend."
the probable cause,
But she hadn't,
certainly
without that.
states knowingly and recklessly cause serious bodily injuries. What are we gonna do today?
Judge, I do need to have a setting for that bond hearing, so if we could have a week resetting.
I'll put it later this week for you.
I'm here Thursday.
Okay.
I'm out Thursday and Friday.
Monday it is, Judge.
Okay.
Just 1 week.
Monday gonna be good. I think it is. I don't know.
It is.
Live day by I live day to day nowadays on this, the way things go around here. Okay. It's set for Monday for hearing. Okay. Watisha Jackson.
She's a plea judge.
Jackson. Why Tisha? But my question is, really, is why not Tisha? Come on up, man. You're Miss Jackson?
Yes.
Okay, you have to go in front of this nice lady. She should swear you in. Thank you. What's this one?
Okay.
Sorry, just us. Get these feeling, that's straight in the picture. Stand in front of the judge for me.
All right, we now call cause number 24CR 1903, the state of Texas versus Watisha Jackson. And it would be nice if a state's prosecutor, we can go without him, but this one was assigned originally to Kyle Gasper.
I'll stand in each other.
Yeah, just. Talking about, just what's that for me, remark. What can you put it? Jackson. Right. There. Good.
Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, Judge.
And Ms. Minaldi is here representing the defendant. In summary, this indictment alleges that on or about June 30th, 2024 in Jefferson County, Texas, you committed the state jail felony of fraudulent use or possession of credit or debit card items. It's like less than 5. And that's what constitutes a state jail felony, which means if convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand? You have a real soft voice. an agreement has been reached where you would be pleading guilty but not found guilty. You would be placed on deferred or unadjudicated probation, which can be up to 5 years in length. You do well, I can shorten it to 1/3 of that if you do well. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Yes, sir.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
You're pleading guilty freely and voluntarily? Huh?
Yes.
Okay, I'm showing you what's marked as State's Exhibit 1. Did you sign that?
Yes.
Understand it? Discuss it with your attorney? Are the contents all true and correct? State's Exhibit 1 tendered into evidence without objection. It's admitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read it. You were guilty of the crime charged in any lesser included offenses, and you were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true, so help you God. State's Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived here.
Yes, Judge.
I'm going to follow this agreement and find you are mentally competent to enter your guilty plea. It is freely and voluntarily made. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm not going to find you guilty so long as you follow the terms and conditions of this probation order. You will be placed on probation for 5 years. It can be shortened by doing well. There will be terms and conditions of probation here. Make sure you follow them. If you fail, your probation can be revoked. You can then be found guilty and sentenced up to 2 years in the state jail. You must complete a theft prevention class, which is a good class to take for all persons, I think. Is there any loss here? Okay, I've signed the probation orders and do well, and
Thank you.
we will reward you. Please see the probation officer. Thank you.
You can find people up. What's not your stuff? So you get it. So I mean, I so they'll. I'm saying this. I get what you're saying. It just seems.
Let me see that last file. Real quick. Thank you.
I'm not, this is kind of one of the one that. I'm not just
Thanks.
reading that. You've seen. Shoving merchandise into the building. Oh, I got it. You said, you can probation for this one. I'm trying to get a see guy. Really.
Isaac Smith.
He's a plea as well, Judge.
Isaac Smith. Yes. Isaac Smith.
Is it, for someone, and I'm not being facetious with this, so what? No, not evidence. That's. Yeah, Walmart, and they don't have the policy where if you make that service from, they just let you take your license plate down. Because they don't want you to, they don't do. That's what I'm saying, that's just, that's heavy. A lot of places do it because.
Come forward, sir.
Smith?
And please see this lady right here. Thank you.
How you doing, Miss Stevens? How y'all doing? Hey, boss.
Mr. Smith, there's a right hand, other hand, right, there.
You're the right hand.
Or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
No.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I mean, I short of that.
No,
What are we doing?
Probation deferred. Day one. There you go. Bring them up, make it gentle.
That makes sense.
I doing mighty fine today.
Consumer here, how's it?
How long has he been in jail now? Thank you. 26 CR 309 is now called the state of Texas versus Isaac Lee Smith. That's you?
Yes.
Present with your attorney, Ms. Medalli, and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, Judge.
All right, in summary, Mr. Laird, this is yours, I think. It's Isaac Smith, arson.
Been in custody 109 days.
Thank you. In summary, it states in this indictment that on or about January 19th, 2025, in Jefferson County, Texas, you committed the first-degree felony of arson with intent to damage a habitation. Damaging or destroying a habitation with intent to damage or destroy a habitation. It looks like Cedar Ridge Apartments. You started a fire and placed it in the wooden patio of the habitation. And that was within the city of Port Arthur. Anyway, it's a first degree felony. Do you understand what you're charged with here?
Yes, sir. Yes, sir.
If convicted, you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty, placed but not found guilty. You would be placed on deferred or unadjudicated probation, fined $500. Is there any restitution on this?
No.
And this deferred or unadjudicated probation will be up to 10 years. You do well and it gets shortened. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Sir.
I told you you'd be fined $500 as well. I show you, and again,
No fines.
how do you plead? Guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty?
Yes,
You have to speak out so she can hear you. The court reporter, you can't, if you're not, they can't take that. I'm going to show you what's marked as State's Exhibit 1. You need to sign.
Oh, did I not, my signature? Oh. Apologies, Judge, I seem to have
I'm
missed
going
it.
to show you what's marked as State's Exhibit 1. Did you sign that document, understand it, discuss it with your attorney, or the contents all true and correct? Okay, you got a soft voice. Make sure she's got to be able to take everything down. The court reporter here, she has to hear you. State's Exhibit 1 is tendered into
No,
evidence
sir.
without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the count charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
Yes, Judge.
If nothing further, I'm going to find that you are mentally competent to enter your guilty plea, sir. It is freely and voluntarily made. You understand and appreciate the consequences of pleading guilty. You are pleading guilty today.
Sir.
Voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this first degree felony. But I am not going to find you guilty so long as you follow these terms and conditions of probation. I'm going to defer any finding of guilt. Now, this is for a term of 10 years, but we shorten it for good behavior. I can shorten it to as much as a third.
Thank you.
There will be terms and conditions of probation. The probation officer will go over these with you here in a moment. Make sure you follow them. If you fail, your probation can be revoked. You can then be found guilty and sentenced in for this particular case, you were looking at any term no less than 5 years, no more than 99 years confinement or life imprisonment. So it's a very serious situation.
Thank you.
He's got how much time right now?
Judge, he's been in custody for 109 days.
The couple of things. The probable cause affidavit that was filed stated that this was a second degree felony, but intending,
It's because of the habitation element. Judge.
you know,
It's because of the habitation element.
because of the habitation, it's a first degree felony.
Correct.
And that's how it was indicted by the grand jury. And it says,
Thank you.
knowing that would endanger the life of an individual as the apartment was occupied and the fire caused damage to the wooden railing. And as apparently a video depicts the defendant doing all of this. All right, here's all right. Even though there's enough evidence to find you guilty, again, I am deferring or postponing any finding of guilt so long as you follow the terms and conditions of probation. You have been in jail 109 days. You're going to be ordered to do 71 more days. I can order anyone as a condition of probation. God bless you. To serve up to 180 days in the county jail. And it's for this, I hardly ever do that. But when you attempt to burn down someone's home, that is as serious as it gets. Thus, this court would be failing its duty under its oath it takes to see that justice is done. If I did place you under the 180 days requirement, because this is a serious thing to burn someone out of their home, attempt to. I can't think of too much more serious than that. And the court's orders must reflect the seriousness of this by its orders. So you're ordered to do an additional 71 days in jail to complete 180 days. If you fail, though, on probation, I hope you don't. You're looking at life in prison. Do you understand what's happened? Fix this. He's not, for the record, he's nodding and not speaking out.
Yes, sir.
Like I've asked him to do. But
Yes, sir.
on the record, he nods. He understands. All right. Good luck. That is all.
It's very good.
Is that it for you?
That's all I have, Judge.
Okay.
Any excuse?
Kelvin, yes, ma'am. Kelvin Anderson. He's still missing?
He's
Yeah, I'm talking.
here wandering around signing people up there. He went back there. Oh. Got somebody's been. They didn't back on purity records. Oh, yes. It's operating chocolate.
Hey, was there anything done on this Nathaniel Clark case, or are we just moving it under the court's orders?
The plea.
I did.
Yes.
I saw him walking with a pad. I didn't know if there was an alternate deal being made. No. Did he take our pad?
Yes. No, I think that's just a briefcase.
Okay, so,
I'm taking my clothes and going home.
so Nathaniel Clark is set for trial, right?
Yes, sir.
Okay. Let me see. I'll go again. Please, now. Pete, you're here. What are you here on? We got you on the, like, 3 on the trial, right?
That's correct.
Bless you. Oh,
You're
yes, sir.
3rd on the trial.
Yeah, I'm third place, third number.
Yeah. Yeah, you don't need anything else, right?
No, this,
Brent, you ready on some stuff?
Yes, sir.
Okay. I've got Kelvin Anderson. Kelvin Anderson. And here's Sean Craig. Giving that back to me. I think Craig. Don. Kelvin Anderson, what are we doing at Kelvin?
Judge, they've made him an offer and he wants to consider his cap 15. His case has voluminous amounts of discovery to it. I mean, at least 45 hours of video there's tons of it. Anyway, I'll bring him out. Honestly, this may be one that might need to be reassigned a little so it can get quicker, just to be honest.
26 CR 365 is called your Kelvin Alexander Anderson here. Mr. Turk is here representing you. Do you understand in this case, you are charged with a 1st-degree felony of engaging in organized criminal activity, which carries with it no less than 5, no more than 99 years confinement in prison or life imprisonment. Do you understand the significance of the seriousness of this case?
Yes, sir.
And all about drugs. Methamphetamine. Drug. And you're charged with engaging in organized criminal activity, which is a very serious set of terms. What are we doing today? This is a decision. Which way are we going?
Judge, well, they made the offer this morning and
Do you want to put it on the record or anything?
he wants to consider the cap. It's a cap of 15 offer. No, and he wants time to consider it.
Who's the attorney on that?
Me, offered him 15 originally, and then he came back with a counter offer of a lower cap, and I said, no, I'll do a cap of 15, and so they're thinking about it. So just take a week or 2, let him think. Then we can probably move. If not, we'll set up trial.
How much time do you need to think about it? You're looking at him. This is your choice.
Really not that long.
Is a week going to be good?
Yes, sir.
Okay. No.
I won't be here next week, Judge, just for the court certification. I'll be at a CLE.
Okay.
We'll do file cases, don't we?
What?
We'll do this week, following week.
I don't have
Okay,
any.
just so the court's aware. Did you?
That needs to be.
Did you want to try, hey, Mike?
Yes.
You still want to ask for a bond?
Bond reduction. Yes, sir.
You want to, do you have a second for the bond reduction?
Oh, I'm objective, so let's eat.
Yeah, just want to give you a heads up.
Well, nobody's filing anything.
Okay, I'll file something
I don't
else.
send it. All right. We'll do it 2 weeks. We'll reset 2 weeks on this.
I'll set something for them.
Okay. Clifton Johnson. Clifton Johnson.
I'm honestly not really sure what this is. This was made up at the request, I guess.
What's a motion to revoke probation?
Yes, sir. It was set next month. And it got moved up last week.
This is,
So I
who is prosecuting it? It's unnamed.
think it's more as the privilege.
Failing to report Failing to never not be intoxicated, failing to provide verification. Failing. He's on probation since about a year. Let me ask on the failing to report. Can you tell me a little bit about that?
About the fourth for our administrative hearing on time. He did show up later after, everybody had kind of dispersed. And in that case, in the NTRP, it does state that he did show up late, but he did show up.
Oh, okay. He was late.
He was late,
Okay.
yes, sir.
Okay, but he got there
He got there.
ultimately. I mean, were y'all able to take care of the business when he got there?
When he got there, he was positive for opiates and THC. Or he was positive before that. And we worked with him on several occasions.
Well, I don't understand. That's not included in here. Why isn't that a condition, a violation in a motion? I've got failing to report, failing to never become intoxicated by being under the influence on or about May 7th.
Yes, sir.
But he failed to report on May 19th. So
May 19th was when we were trying to address it. I apologize, sir. I misspoke. He did fail to report on the day we were trying to address the positive drug test. And
which was May 7th.
it was May 7th, yes, sir.
Okay. All right. So that's covered then. Then that's number 2. Failed to provide verification of performing community service hours as required.
He was not reporting and doing that regularly.
He's been on probation since June of 25, a year. And so this was all kind of falling apart
What else, sir?
in May. June. How many hours of community service has he performed?
He's a total of 40. Twice.
But that was picking back up, right?
It had picked up recently.
He was starting to do it recently.
Yeah, no, but it took a while to get going, right?
He was
This
doing
does-
it.
We're supposed to be, we placed him on probation on June 4th of last year. And as of May 19th, a year has gone by. He had, according to this, he failed to perform a single hour of community service for almost a year. Is that right?
Yes, sir.
Yeah, you have a busy schedule, do you? That you were unable to do community service? I wonder. Oh, no. I'm just curious. Are you homeless or anything like that?
No, sir. I was up under the state rule to take care of my wife. She just push-fully disabled.
What's wrong? What's her physical disabilities?
She got carpal she got cancer, she got a heart.
How long has she had that? Years?
For a while.
Wow.
Yes.
Well, what's the status? Is she getting better, worse, or stable?
It's getting worse.
Worse. Do y'all have children in the house?
No, it's just me and her. I mean, I cook, clean, I do everything with her.
Oh, wait, are you working somewhere as well?
I work. Well, I do self-employed. I'm a mechanic. I do self-work to try to pay my fees.
Yes, sir.
And I work at 11th Street Bingo Hall, where I can go do work, and I help my sister a lot out with that too. So it'll help me to continue to pay my fees if I ain't got no other way to pay.
And I'm trying to figure out is he accurate on some of this or
He is
inaccurate?
accurate on that. His
Good.
his wife is infirm. That is he claims disability
He, what?
through her. He claims he gets disability through her. Not through her, but for her. And he pays his fees somewhat regularly, he pays $95 to $100 a month, like he can when we enforce it or when we start pressing him as we usually. The problem that I had, Your Honor, was that December the 2nd, he committed an offense. We had administrative hearing on that date. We gave him 90-day review. We allowed him to let charges rise and fall on their own merit. And 3 days after, he was given a written letter by me saying he had done wonderful, done everything he's supposed to do. He tested positive for opiates and THC. And he needs to understand that he's on high medium risk caseload. He does not have a lot of room for the continuous slip ups.
Which is not in the motion.
What was, okay, I don't see that in here,
It's not in the
right?
motion. It's not before the court.
No, it's not.
What are we gonna do about it? What are y'all gonna do? Pass
Well,
on it or?
Well, we didn't offer to pass on. We offered this hearing because he does keep continuing to misstep.
Well, we need to, if we're gonna move forward on a motion, all the allegations of mistakes need to be included in it.
Sir, it was my understanding that once I put an administrative hearing in, I could not readdress those issues. So I apologize if that's on me. But on a administrative hearing that was signed December 8th, some of these things were addressed.
Okay. Well, number two is what number two, never become intoxicated or be under the influence of intoxicating substance. On or about May 7th, he tested positive for opiates and tetrahydrocannabinol. Okay, so that's in the motion as allegation number two, even though it's kind of generally worded. That's what they're referring to. That's okay.
December.
When asked about this use, he's told the officer he'd been going through some stuff. Okay. Well, that's doesn't really. That's not a great response. Yeah. All right. So, what are we going to do? Just have a hearing on it, I guess. Go ahead.
Your Honor, he's not difficult to work with.
He's what?
He's not difficult to work with. It's just the missteps that keep happening. If there was some.
Do you want to complete the probation or not?
Yes, I want to complete.
All right,
everything.
let's give him a chance. Yeah, let's try to
I
help
want to
him.
complete everything. It's not.
But what we're going to do is I'm going to put you on a drug patch.
Yes, sir.
So that and the drug test will show.
Yes,
We're not going to have to catch you. It'll show up on the patch and it comes off. We'll test it. And if it's positive, you'll be accountable. Sounds like you got your hands full, but do the best you can. You know, some of this is hard to deal with, but you're not going to be able to help your family take care of medical concerns if you're getting illegal drugs.
Yes.
Using illegal drugs, that's putting the drug and your use of drugs ahead of your family's needs, and that's not right.
Yes.
You should remember we're third. Everybody's third.
Yes, sir.
Spring beings first, others are second, and most important, family, we come in third. So, pattern for selflessness. Cool. Okay, what we're gonna do is keep this thing open and we'll just, I want to review in a couple of months.
Okay.
See how he's doing, okay? But it's over your head, so don't fall back, move forward, do better.
Thank you.
Anything else? That's all. Mishaw? Jamal Mishaw?
Probably today. And it's done that same thing. You got it, what you doing? See what anything else?
No.
You got Mishaw? We're bringing him out.
Yes, sir. That should be a plea.
How much time does he have for false claims? Michelle.
Michelle, raise your right hand. You swear or affirm that you're full proof and that this is true stuff about. You got your right thumb print. This place that you laugh.
On probation. Wasn't he?
I don't think so.
I need to start from that.
I started out.
Okay.
Honestly, I don't know off the top of my head. If he was on probation for it.
Don't believe so.
Yeah. And he went on to
I think it kind of was.
Okay, I don't remember that.
I need a new.
One more time.
Get a new video.
All right. You get up again. Okay, and then like the flat right
There's
here.
another.
No, he was,
Yeah, that's good. That's like it, right
A
there.
different Michelle.
There. Okay, you go stand for the judge.
It was a Mishaw mistake. 26 CR 851 is called Jamal Deontay Mishaw. That's you.
Sir.
Present with Mr. Turk, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, Judge.
In summary, sir, this indictment alleges that on or about January 7th, 2026, in Jefferson County, Texas, you committed the state jail felony of credit or debit card abuse. Do you understand what you're charged with?
Yes, sir.
If convicted of a state jail felony, you are looking at no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
An agreement's been reached in your case where you would be pleading guilty, found guilty, sentenced to 2 years in the state jail. That would be suspended. You would be placed on regular probation for 5 years. And you would be under terms and conditions of probation. But most importantly, you would owe restitution to the victim of $1,523.65.
Yes, sir.
Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir, I did.
Did you work for the Swati family?
Sir?
Did you work for them?
Yeah.
Did you know that?
I asked you, did you work for that Swati family?
Oh,
The
no.
Swati. You didn't? Because they're business people in this community.
I mean, we're both grass, but I did work. Yes.
Go to the church and he could put that in my file. It's just literally.
Oh, I see. It states that the complainant's wallet had been stolen just a few minutes before he tried to cash or get cash for the card at the bank.
So you can tell him that you're gonna do what I'm supposed to do. Sure, the process, that's what Jill. She's doing. That's probably have to tell you the family processes. Processes.
All right, once again, you'd be pleading guilty, sentenced to 2 years in the state jail, then that would be suspended. You would be placed on 5 years of regular probation. And other than other terms and conditions of probation, you must pay back restitution in the amount of $1,523.65. And does the restitution go to the victim complainant in this case? Or does it go to Third Coast? I don't know. Can't tell.
I'll need to determine that, Judge, just to be certain.
Okay,
I'll get
but
that-
restitution in that amount would be owed. Do you understand?
Yes, sir.
To somebody here who was
It just has
victimized.
to be paid.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, guilty or not guilty?
Plead guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I show you what's marked as State's Exhibit 1. Did you sign that document?
Yes, I
Understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
Objection.
Without objection, it's submitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true, so help you God. State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived here.
Yes, Judge.
I, if nothing further, will follow this agreement and find you are mentally competent to enter your guilty plea. It is freely and voluntarily made. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this state jail felony of credit or debit card abuse. I now find you guilty of this state jail felony. I am following this agreement. You are hereby sentenced to confinement in the state jail for 2 years. That confinement is suspended. You are placed on regular probation for 5 years. You must pay restitution in the amount of $1,523.65. There will be other terms and conditions of probation, which are normal and customary for this type of offense. Failure to follow these terms and conditions of probation can result in revocation of probation, and you can be sentenced up to 2 years in the state jail. How long is it going to take for you to get this money paid back, do you think?
It'll be less than 2 months.
We must have.
I'm going to give you 3 months to do this, okay?
Okay.
All right. You've got 3 months to, and we'll note that payment within 3 months. Every day there, the person who is stuck with the responsibility loses interest on that every day. And that's, so it gets further and further behind in a loss. That's why it's necessary to get that paid back quickly. That's the important thing on this.
Yes, sir.
You do well, I can shorten your probation.
Yes, sir. Thank you.
Anything else? That is all. Please see the probation officer. Thank you. Then we need to figure that out also. Who's which one is, which entity or individual? Miss Swati?
Yes.
Okay,
I gave that information to the
great.
probation.
Okay. I have Jeremy Nickens.
You. First. It's got new stuff.
Feel good, Lord. You got some prior convictions here, huh? I mean, this is a habitual felon status, right? Ooh. We're okay. Jeremy Nickens.
Yes, sir.
Do you need to
Yes.
go in front of that
Come here,
lady?
please.
Yes, ma'am.
Raise your right hand for me. Be square or firm, tell the truth, whole truth, and nothing but the truth, self you got.
Yes, ma'am.
Okay. Pick up your right thumb print. Give it flat in the box right there. Yeah, I need it way darker than that.
Yes, ma'am.
Put it outside the box right there. Let's do it one more time. And right there.
Right here in the
No,
box?
no. Check that. Okay, thanks so much.
Yes, ma'am. You still. To get them talking to you. Back there. Are they in here? Let me see this right here. Okay.
All right, in 26 CR 452. You are Jeremy Wayne Meekins,
Yes, sir.
and you are here with Mr. Kirk, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, Judge.
All right. In summary, this indictment alleges that on or about February 24th, 2026, here in Jefferson County, Texas, it is alleged you committed a third-degree felony of assault, family violence by intentionally, knowingly, or recklessly causing bodily injury to a person who's a member of your family, household, or a person with whom you had a dating relationship, and you intentionally, knowingly, or recklessly impeded the normal breathing or circulation of the blood of the complainant by applying pressure to her throat or neck, and or by blocking her nose or mouth and placing your hands around her neck and squeezing. This is what we called choking. Which
This one was Reggie's.
I mean, there's only one intent, that's to seriously injure or kill someone when you squeeze their neck, because breathing comes in handy for human beings. It's a necessity of life. All right, so we've got a burglary of a habitation conviction in '08 out of Jasper County. After that became final, the defendant committed unlawful possession of a firearm by a felon and was convicted in Jasper County in February of 2010. So thereafter, anything after that, you're an habitual felon. The next paragraph states that after those first two convictions were final, you committed unlawful possession of a firearm by a felon, a third-degree felony, once again, and were convicted out of Jasper County in 2013. After that, third conviction was final. You committed the felony of burglary of a habitation and were convicted of that in May of 2022 in the 252nd District Court of Jefferson County, next door. And also on that same date, you were convicted of another burglary, a second burglary of a habitation at that time. So you had the status of an habitual felon 3 convictions ago. And so now you're here with the third-degree felony of assault by choking somebody. Is all that about right?
Yes, sir.
The offer is 8 years? Is that it?
Yes, sir.
No. Not even close for this call. When you choke somebody, you're attempting to kill them. 3 convictions ago, you were a habitual felon looking at 25 to life. 3 convictions ago. Not on my life. Set it for Trump. Next is Chester Smith.
On the Nickens, is it something that the court would want 25 or more, or is it something we could have?
I can't enter into that. That's y'all's
I
business.
just wanted to see if the court had just trying to get some guidance.
No, it's 8 years is not it.
Just trying to get some guidance. When I talk with
This is 4th time being a habitual felon and he's choking somebody.
I get it.
It's just
wanted to know what we might satisfy.
that's what he's going to do to his wife. What would he do to somebody he didn't like? He wasn't
That's assuming he likes
married to and pledged love to. That's just that was such a bad example here.
No, I mean, he, I don't know if there's, they were all on the other side, but I think we're going to, we didn't want the 6. So. If I remember correctly.
Where's Chester?
He's on the other side, Judge.
He's on the other side.
Do we need him is the question.
I don't think he wants the 6. So
what were we? This was what an announcement. What were y'all going to do?
Can I get one more announcement on that, Judge? I think I need to talk with him this morning. I apologize for that.
How much time is a week going to be? Okay.
Can we have 2 weeks?
Yeah.
I won't be here next week.
Okay. 2.
That's the only reason I would.
That's right. You said
I won't be here.
All right. On Chester Smith, he said 2 weeks, please, for an announcement. Thank you. Next is Antonio. Yeah, what's that? Valian? Antonio Valian, please.
Mr. Mallon,
Yes, ma'am.
No, wait. Go see that lady. Thank you.
Yes, sir.
please raise your right hand.
This one?
No, the other.
Yeah.
There you go.
Stepping up,
Yes, sir. Yes, ma'am.
each of your right thumb print, right thumb.
This one?
Yep, that's the one.
First tempo, just press straight down in the glass.
Okay, get up one more time,
Okay.
same one.
Oh, shit.
That's okay, look, wait, do it again,
Press it.
right there. Okay, good job, go see judge.
Okay.
And we now call cause number 26C0943, the state of Texas versus Antonio Vallon. And that's you,
Yes, sir.
present with Mr. Turk, your attorney, and the state's attorney. Does the defendant, as Mr. Laird, does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, Judge.
We just going on paragraph 1?
Yes, sir.
Yeah.
That was sufficient.
Allegation 1, paragraph 1 states that on or about April 14th, 2026, in Jefferson County, Texas, you committed the second-degree felony of robbery. Do you understand what you were charged with here?
Yes, sir.
If convicted of a second-degree felony, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty and found guilty, sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation for 10 years. There would be terms and conditions of probation, which are normal and customary for this type of offense. Was there any loss here?
No, so they caught him.
Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Good.
How do you plead to this as alleged, sir? Guilty or not guilty?
Hey, guilty. That's it.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. Is that yes?
Yes, sir.
Yes, so she can hear. The court has to hear that. I show you what marked as State's Exhibit 1. Did you sign that document?
Yes, sir.
Understand it? Discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered in
No objection.
without objection admitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read for you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All true. It states, so help you God.
Yes, sir.
State's Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived here.
Yes, Judge.
I'm going to follow this agreement, sir. If nothing further, I'm going to find you are mentally competent to enter your guilty plea. It is freely and voluntarily made. There is sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this second-degree felony of robbery. I am following this agreement. You are hereby sentenced to confinement in the institutional division prison for a term of 10 years. That confinement will be suspended. You were placed on regular probation for 10 years. There will be terms and conditions of probation, which are in this probation order that the court is signing. Please make sure you follow this. If you fail, your probation could be revoked and you can be sentenced to up to 10 years in prison, which we don't want. So do well on this and move on and be the best you can be.
Yes, sir.
All right, I've signed these documents. Please see the probation officer and understand, sign those, and you begin probation. Good luck. I can't believe it. John Cherry Freeman.
Heinous plea. Right there. Yeah, right there.
She needs to go in front of the lady.
Yes, I'm giving just 1 second. I'm making copies of my fingerprints.
Okay, that's stand right there and wait. She'll be back in a second. Both. Look for. Got on self-defense. Looks like stuff. You supposed to get started unjustified if they're provoked. The other use for activity of someone lawful force. Let's abandon that. It felt like you couldn't say anything. Well, the other continues, you know, we just said the other folks against them, so they have, but no reason to. Anybody get all that, but I want to do that. Well, yeah, but anything. Choose to talk, I don't see that. It's right up there. Right there.
Raise your right hand, you swear or affirm to tell the truth of the matter and to the truth of you got? Yes. Pick up your right thumb. Place it flat right there on the box. Never more than that. Okay, place it right outside the box. Okay, there's some project.
Right there. 26 CR 911 is called the state of Texas. Versus Sherry Freeman, that's you? Yes?
Yes, sir.
Yes, she has to take everything down and, okay.
That's
And
right.
sometimes, sounds like, and then she doesn't get it right. And we don't want her to make a mistake, but she doesn't make many mistakes. All right, on or about February 5th, 2026 in Jefferson County, Texas, it is alleged you intentionally, knowingly, and recklessly threatened to commit an offense involving violence to a person, namely aggravated assault with a deadly weapon and murder with intent to place the victim in fear of imminent serious bodily injury, and that the person who is the complainant here was a peace officer of the Beaumont Police Department. This is a state jail felony, and it's very ironic that you were charged with terroristic threat against a peace officer, and this is under cause number 26 CR 911. What are the odds of that? 9/11. On 9/11, we got a terrorist threat here. This is a state jail felony. If convicted, you face no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand the punishment range that you're facing for this, Mr. Freeman?
Yeah, I understand making the threat to him,
Better off.
but I don't understand the part where you're saying that I was trying to cause any kind of bodily harm with a weapon. Did you mention that?
The indictment states that you recklessly threatened to commit an offense involving violence to a person. Namely, you had threatened aggravated assault with a deadly weapon and murder, which placed him in fear of imminent bodily injury.
The exact words I stated to him, I said, "Mister, would you please stop playing with me before I use that weapon on you?"
No, that's not what's here in
That's
the
what I
trial.
said.
I'm sorry. When I speak, you have to stop, because when we both speak over each other, she can't take everything down. And that's interrupting, and it's rude. We learned when we were children that wasn't proper. It states that you stated to him, "I am a crazy MF and you said the words, "And I will steal that gun and blow your head off." It's on the record. It's on the recording. Do you remember even doing that? Doesn't that sound like terroristic threat? All right. What I'm gonna do is, I'm not gonna take this deal. We're gonna go to trial and I'm not gonna accept the deal. We'll let a jury decide her fate. That is all. Thank you.
You're welcome.
Set it for trial.
Have a good day.
Jadrian Bob, please. Jadrian Bob.
Man's long, right?
Was that, what is it called?
Daydream Manning.
Daydream Manning Bob?
Sorry.
What are we doing on this one? John?
This is the trial or not.
Okay, we can get him out. Mom. Oh, we have a Dr. Rapon report
Yes, it's called.
and it's competent.
That's what I agree. It's called.
What we've got is, okay, 24 CR 2475 is called Adrian Tristan Manning Bob. Is that you?
Yes, sir.
And you're here with Mr. West, your attorney, and the state's attorney. You were charged with the second degree felony of assault on a police officer, which carries with it no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand what you're facing here?
Yes, sir, I understand.
Okay. What are we going to do, John? It's been announced.
It's set for trial docket. We've, whenever everything, looked at the videos for the discovery, there's a state offer of 5 years. My client has rejected that one, and based on looking at the discovery, we'll go to trial.
Okay, it will be set for a trial. We're going to get this as soon as we can, sir. Okay, that is all. Thank you. Michael Resendez.
The plea offer, Your Honor.
Oh, it's pro. Yes, my office, she was working for a minute.
Hey, that woman here, what is her criminal history?
Very minimal. I don't remember.
I didn't see anything in the indictment on
No,
prior criminal history.
I think it's based on. I'll talk to her. You saw the box.
Thank you.
Right. 20-34701 is called the State of Texas versus Michael Anthony Resendez. That's you?
Yes, sir.
With Mr. West,
There's another case too, Your Honor.
your attorney and the state's attorney? Yeah.
Yeah, there's
There is.
there's a new TRP and there's a new case. It's all
Okay.
part of it.
And then we've got a new case. What are we doing today?
8 years, both of them, CC. Revoking based on this small offense, new offense, 8 years, and then get 8 years on this.
34701 and 20. Okay, so the motion to revoke was earlier in time.
Right.
And there's a motion to revoke unadjudicated probation in this 34701, and you are Michael Anthony Resendez.
Yes, sir.
And here with John West, your attorney. Does the defendant waive a formal reading of this motion to revoke unadjudicated probation in this 34701? Can we proceed in summary?
Yes, Your Honor, please.
In summary, motion states that on June 10th, 2021, in this criminal court of Jefferson County, Texas, you were placed on 10 years deferred or unadjudicated probation for assault, family violence by choking, a third-degree felony. Is all of that true? Yes. Okay. Fine. Nothing pleasing there. I have an indictment, a pending indictment, 26 CR 1151 that alleges the defendant committed assault on or about May 16th, 2026. Allegation 1 states he committed assault and family violence on or about May 15th, 2026. Is that the same thing? Is that the same event we're talking about?
It should have been May 16th, is what my sheet says they put as 16th. 15th is what it says on there, or?
It says 15 on the thing.
But
Yeah, it's on or about covers it, but that's the same.
It's on or about. I just want to make sure that's the same.
Yes, sir. It
event
is.
we're talking
Yeah.
about.
It's the same
Okay.
one, Jeff.
So he knows you're going to be the motion will be to revoke probation will be based upon the allegation of this new indictment so you get you by committing one bad act, it gets you in trouble in two cases. Do you understand?
Yes, sir.
And they're going to be running together
That's the
in this. That's your plan. All right. So you, again, allegation one states you committed the offense of assault, family violence by strangulation. Oh boy, that's two in a row. We have here on or about May 15th, 2026 in Jefferson County, Texas, which is a violation of condition one of your probation order. Condition one of your order states you shall commit no offense against the laws of this state or any other state or of the United States. And assault is a violation of state law. Do you understand what you're charged with here in allegation one of this motion to revoke probation?
That's right.
Is this true and correct as it is alleged, sir?
Yes.
And are you pleading true and correct to this voluntarily and because it is true?
Yes.
Do you understand that a voluntarily and knowingly made plea of true to one or more violations of probation, that is enough to grant a motion to revoke probation? Your probation can be revoked and
All my witnesses are served now.
you can be now found guilty of this third-degree felony of assault, family violence by choking that you were placed on deferred or regular or unadjudicated probation for. And you could be sentenced up to 10 years in prison. Knowing that, do you insist on pleading true today? Yes?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. All right.
That's what was written.
Where to begin? This is this indictment, what you're pleading true to, what you were placed on probation true, has the same issue. You choked somebody. When you put your hands around somebody's neck and squeeze, there's only one intent. That's to seriously injure them or kill them. We put you on probation for this. And you're back violating probation for choking another person. What is it about that? I mean, you could kill, this could be potentially, you can just run up a number of people killed. This choking someone, you shut off they have to breathe. When you close your ability to breathe, you can die. You understand that? Yes?
Yes, sir.
Okay.
I'm sorry.
Why do you keep doing this? I mean, it's really not any less lethal than shooting them with a gun. When you strangle somebody, strangulation is what it is, which is very serious and inhumane. But that's to kill someone. These are loved ones, right? Yes?
Yes, sir.
Well, it begs the question, what would you do to someone you didn't know or like if you got angry with them? If you're going to strangle your loved ones. And it's another female. It's a different female, right? The motion is based upon, well, you were placed on probation for assault, family violence by choking a female, and now it's a different female you're choking that's causing your probation to be revoked, right?
Yes, sir.
And if they die, we call that murder. You're looking at the life in prison. All right. On back to 34701. Again, you're looking at up to 10 years in prison and
Yikes. Turn the temperature down in here. It just got scorching hot. Listen to that tone. Judge Stevens is disgusted. He is laying out the brutal truth. When you choke someone, you are attempting to kill them. There is no gray area. And he's pointing out the pattern. This is the second female he strangled. The judge is calling him out and asking, what would you do to an enemy? This is a masterclass in sentencing morality. He's not just punishing the act, he's exposing the why.
an agreement's been reached in your case where your probation would be revoked. You would be found guilty and sentenced to 8 years in prison to run concurrently with the new strangulation case. Do you understand? Is this your plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
I've never done, I can't even fathom putting my hands around somebody's neck and squeezing it. I've never done that in my life. I've never even thought about doing that. I think,
Don't remember doing it today.
sir,
Don't remember doing it. I was.
well, but you did it. You're admitting to it. Were you on drugs or something? No?
I'm gonna get ready to go, but look at also.
Good luck on finding a woman to live your life with when this sort of thing gets around. Like half the population are females, you know. That's who you prefer strangulate.
Do you have
Strangle.
organism?
But this is fixable. But you got to treat a lady with dignity
Well.
and respect, right?
I'm gonna need some songs. Okay.
This person, were you married to this person that you were on probation for?
We were engaged.
Sir?
We were engaged. We've been together 6 years now.
Yeah, you were engaged. I mean, it's about as close to marriage as you can get, but you pledged love and promises. And I'm sure this is a very good person. You lost them as a partner who wants to be around this. You gotta, you know the difference between assaults and love. This isn't intimacy. This is not. Yeah. I've been married 40 years. My God, I can't even imagine.
Is there anybody else who need other?
My partner of life. I'm sure these are wonderful people. Well, God, you've got to fix this and treat the lady like they need to be treated with respect and love. Hurt them. Let me ask you, when you grew up in your household, was that something your dad did or anything?
My parents been separated for 23 years now.
Yeah, but I mean, did he commit assault on her?
My stepdad's used to beat my mom and.
Sir,
My stepdad's used to beat my mom.
was he a good person? No. Well, and your mother should never be mistreated by something, you know that. And so I don't want that pouring over to you as a lifestyle. That's not the right thing to do. And I'm sure knowing about it makes you upset that your mother would be victimized by someone, much less someone who said they love you. But don't be carrying on this bad habit in another generation. You make your own choices. You make your own choices. Fix this, sir. All right, I'll show you what's marked as State's Exhibit 1, John, help me here on this. Did you sign that? Understand it? Discuss it with your attorney? Is everything true and correct? State's Exhibit 1 is tendered and
No objection.
without objection admitted. This states if I follow this agreement, among other things, you have no right of appeal. I'm going to follow this agreement on this. If nothing further, I'm going to find that there is sufficient evidence supporting this motion to revoke unadjudicated probation, to grant it by a preponderance of the evidence or greater as allegation 1 is proven true that the defendant committed the offense of assault, family violence by strangulation on or about May 15th, 2026 in Jefferson County, Texas, which is a violation of condition 1 of this motion to revoke probation order that he was placed on probation for, which states don't commit a crime. Thus, this motion is revoked and your deferred or unadjudicated probation is hereby withdrawn and revoked. Earlier in this case, when we placed you on probation, you had pleaded guilty to the 3rd-degree felony of assault, family violence by choking voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt from that State's Exhibit 1 that you signed when we placed you on deferred or unadjudicated probation some 5 years ago. I now find you guilty beyond a reasonable doubt based upon your revocation, the revocation of probation in this case. And you were hereby found guilty of this assault, family violence by choking, 3rd-degree felony. I'm following this agreement. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 8 years. You understand what's happened in this case?
Yes, sir.
We go then to the new indictment, 26 CR 1151. Well, it didn't fall into the trash can like they've not, like happened before, which is always I believe that's a message from up above when that goes into the trash.
I think I need to dismissal.
All right, in this 26 CR 1151, the state of Texas versus Michael Anthony Resendez here with your attorney, Mr. West, does the defendant waive a formal reading of this indictment? Can we proceed in summary?
Yes, Sean, please.
In summary, this new indictment states that on or about May 16th, 2026 in Jefferson County, Texas, you committed the 3rd-degree felony of assault, family violence by choking a person you had a dating relationship with. Do you understand what you're charged with here, sir?
Yes.
And this is a 3rd-degree felony like the other choking case that we dealt with on the motion to revoke probation earlier, which means you face a term if convicted of no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes.
Yes.
Yes, sir.
An agreement's been reached in your case here that you would be pleading guilty, sentenced to 8 years in prison to run concurrently with the previous case, 20-34701, the earlier choking family violence case that you were on probation for which your probation was revoked and you were sentenced to 8 years in prison just a few minutes ago. Is this the understanding of the plan in this case as well?
Yes.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead guilty or not guilty for this case?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. You have to speak out so she can hear. Yes?
Yes, sir.
I show you what's marked as State's Exhibit 1. Did you sign that? Understand it? Discuss it with your attorney. Is everything true and correct here?
Yes, sir.
State's Exhibit 1 tendered.
No objection.
Without objection admitted. This states as before, you are mentally competent to enter your guilty plea in this case voluntarily, knowingly, intelligently. You understand and appreciate the consequences of pleading guilty. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God. States Exhibit 1, part of the record for all purposes. Pre-sentence report is waived here.
Yes, please.
I'm going to follow this agreement. I will find that the defendant is mentally competent to enter his guilty plea. You are doing this freely and voluntarily. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from States Exhibit 1 admitted here to support your guilty plea, to find you guilty beyond a reasonable doubt. In this case, I find you guilty beyond a reasonable doubt of this third-degree felony of assault, family violence by choking the neck of the complainant. You are hereby found guilty beyond a reasonable doubt of this third-degree felony. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 8 years. These sentences of 8 years imprisonment in each of these cases shall run concurrently. Do you understand what has happened today, sir?
Yes, sir.
And on each of these judgments, it will reflect that these are crimes of family violence. Anything else? That is all.
That's what I'm sure.
Do better.
That's good.
There we go. Jerry Freeman? I did revoke that. Oh, rejected that. So. Michael Resendez.
That's what we just did.
That was the one we just did. Missed that one? Okay. And I think.
Kind of the parameter of it. I haven't got those.
What did we decide to do on, what did I say we were gonna do on Sandy Cyrus?
You did it, please,
You did,
Yeah. Everything.
hold on.
There.
There you go. I didn't check it off properly. There it is. It's good. Sandy Cyrus, done. And Jeremy Neekins,
They took.
and Nathaniel Clark was also rejected. Is there anything we're missing here?
We need to deal with Solomon in the trial document.
Okay, what is it we're dealing with? Oh,
Proceeding judge. We need to bring him out.
bring him out, please. This is, Rafael Solomon. Here, help me out. What are we gonna be talking about?
Last discussion I had with him, he was considering an offer and asked me about doing subpoenas. I told him to give it his standby counsel.
Which is whom?
I'm also.
Oh, okay.
Yeah, that's why I'm sticking around, figure out what we need to do.
Well, Mr. Solomon?
He's next door, Judge. He's.
Oh, they're getting, okay.
I'm looking to help out some of my work bits, but I just got sick this month. This was broke. It's good. I recognize it. Was actually judging. Say last year. He still got more than 300 lives. This was 100 times more than the regular. That's amazing. Yeah. Okay.
Just like they did this, how they did for me.
What have you been fighting for? Yeah, that me. Sitting, listening to.
What was the child's age on this one?
16.
No, actually, the second, the first one, second. Other boss.
All right, where are we on this for trial?
Right.
You ready? Okay. We've got it. Yes. Well, we're back on 22-39310 and two other cases involving Mr. Solomon. What do we need to do today to make sure that we're ready so we can get this thing to trial like we want?
Mr. Solomon, I believe has completely reviewed all the discoveries, so we're good there. He was made an offer last week and had still wanted to consider it. In reviewing media discovery with him last week, he had talked about trying to subpoena some records, and I advised him, since he's representing himself, he would either have to do that or get with standby counsel.
I didn't get to completely look at all the discovery. I know there was media that I didn't really get to see. I think you mentioned it was sensitive material or something.
He's referring to one item that is child pornography that I told him I wasn't going to review that, but I gave him, I gave him an entire written report of everything that's contained within it. He's been reviewing that while he's seeing media.
You mean as far as the chat one?
What you're looking for is not within my records. That's why you talked about getting a subpoena, sir.
No, I was talking about regarding the media. I had no idea what the media is about. Child pornography, whatever. Child pornography, media.
Right, we don't show that to people.
Right, did you say there was a writing?
I gave you a written report that was that thick that you were reviewing whenever you.
I know what you were referring to.
Yes.
What else do you need so we can get to this trial that you want, obviously?
Right. What I needed was actually, as I mentioned, or I mentioned last week, and I came back Friday, but I never got a chance to speak to my standby counsel.
Or do you need to talk to him today? He's right there.
I wanted to see about subpoenaing the website and getting the chat and the chat dialogue.
Okay. Y'all need to talk about it and figure out how to, what needs to get done, if anything is possible.
It's possible we go save this. Try that.
What else?
Also, records from Kirbyville Police Station. I believe, they did an investigation there. I know that
Any and all reports from them are included in discovery that he's been given.
I don't think it's all of it. I believe some may be missing.
How would you know there would be something missing?
Because I have seen it actually. Again, with my previous lawyers on my defense during the time when I had lawyers, I was able to see some of the discovery and saw quite a bit of it. And
what does that have to do with what you're asking for out of the the police? Where was it? The police department?
so there's this is the initial testimonies given by the witnesses there in Kirbyville. No. All the witnesses all together. Also, basically that's what it is.
The initial report started in Kirbyville, where the victim lived with her family. When it was determined that the actual offenses were occurred here in Jefferson County, it all got transferred here. All the reports that we know in existence are in discovery, and he's been given a copy of.
Everything you have, he's been given?
Correct, Judge.
All right. Anything else? That's what he's saying.
Well,
What is it that you know that exists that he's not given?
I've looked at what I was given. It is not the same thing that I actually sold.
Say that again? I'm sorry.
I'm saying what I've been given or what I've been disclosed from him as far as the reports or the initial investigation reports is not what I actually read as and I've seen previously as far as
Like, give me an example of what I don't follow you.
okay, I'm speaking about when initially my witness supposedly made this report. They walked into the Kerberville local police station and they gave statements there, written statements signed. The reason I need it, I know it exists because it's inconsistent with what this report show, and that's works towards my defense, I believe.
Well, they either exist or they don't, and the state says they've given you everything, and that's all we can do. Anything else? When are we able? When can we specially set this for a trial, folks?
State's ready, Judge.
And then
You're not ready yet. Is that right?
I mean, I definitely need this to spin and get the chat forum with the chat thread from the adult website where I initially met the witness. That is very.
He's trying to develop
that, John.
He's trying to file a subpoena for that. Whether they turn it over, or not, I don't know, but we can.
He's trying to develop a defense about the age of the person, and I've explained to him that that's not a defense to this offense, Judge.
This whole case was, I mean, everything matters. I've seen the evidence disclosed to me, and if I'm able to get that chat thread, it would actually shed light to some of the false testimonies given. You know what I mean? It's part of it. Again, it's important.
However you want to accommodate him, Judge, state's ready.
Or get that thing, that particular thing done. Let me know when that is accomplished. We'll set trial.
Your Honor, I have one more thing to say. The written report he was talking about, it's basically SMS texting between me and witnesses and whatnot. I need to see about the authenticity of that message there because
I don't know.
It's not.
See, I don't know what you're talking about.
John,
do you know what he's talking about?
It's not reliable.
It's a Cellbrite report from phone data, Judge.
There are messages missing there. I specifically remember. I don't know if it's just been it's been doctored. I don't want to
Y'all got from the state. You have.
Your Honor, we've had these records back to the time in which he had counsel representing him. We filed those records with the proper notice that we would be using it as business records. There has been no objections to any of that. I provided him the entire written report just to make sure that he's being given the entire amount.
What is it that he doesn't have?
Well, he's claiming that there's things that aren't there, but they're just claims.
That you have, that you can give him. What else is there that you have not given?
I've given him everything.
All right. You can shake your head all day long, but you're going to have to show that he's hiding something because he has more to lose than you do. He's this man. And you interrupt me. The point is those professional people have never been accused of wrongdoing, and they say they have submitted to you all that they have in discovery, and you're saying no, they haven't. You're going to have to prove that there's something that they don't have, because that's the way it works. They've submitted, and their law license reputation is at risk, and I've not known them to hide the ball. They provide what they say, and there are severe ramifications if they are misleading. I trust the way they've done things, and we've never caught them misleading people or acting unprofessionally. You say, no, it's not. They say they present it to you, and the way is if you, it's going to be your burden to figure out what's missing and what exists that hadn't been given to you.
No, the paperwork that I have seen, that has been given, that I was able to review. I mean, it's evident that messages are missing. I don't know if they've been deleted or what.
Okay, during the trial, if that's your strategy, you can bring that up in the trial, and it's up for the jury to decide what's the truth. That's why we have jury trials. They're the ultimate determiner, and we've done this 615 times, a world record in this court, and jurors take care of their business, and that's what we'll do. We'll leave it to them to decide what the facts are.
And there it is. The gavel comes down. Judge Stevens is a legend because he lets the pro se defendant air his grievances about missing messages and conspiracies. But then he reminds him of the bottom line. The jury decides. The judge is basically saying, bring your evidence to the trial because crying in my courtroom isn't a legal strategy. This is how you run a courtroom with authority, respect, and a touch of sass. That was an absolute roller coaster, folks. Drop a like if you think this judge is a legend.
That is all. Thank you.
Judge Atkins special said this
Yes.
on October the 26th.
What does everybody say about that?
90
October 26th?
That sounds fun.
Done. And especially said, y'all be ready. We will try him first on that and get him, get his wishes accomplished. Okay?
You want to talk to me about?
Thank you. That is all. Anything else? We're in recess.